It's 2025 and a new year means brand new opportunities. And for a lot of you out there, I know you've been thinking about one thing over the holidays, and that is starting your own business. But you have so many questions like how do I get started? How do I come up with a brand? How do I even sell stuff to people? And what am I even going to sell? Now take a deep breath. Shopify has got you. Shopify makes it simple to create your brand, open for business, and get your first sale. And you can get your store up and running easily with thousands of customizable templates. You don't have to be a coding nerd or a design geek to get this done. All you need to do is drag and drop. Shopify also helps with the details like shipping, taxes, and payments from one single dashboard, so you can focus on the important stuff, like growing your business. Established in 2025 has a nice ring to it, doesn't it? Sign up for your $1 per month trial period at shopify.com/truecrime, all lowercase. Go to shopify.com/truecrime to start selling with Shopify today. Shopify.com/truecrime.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my third wheel co-host, Brett.
No, Alice, right in the heart. Just hitting me right here.
Brett, before,
not even in the back, just right in the heart.
Before you get too dramatic, let me say why. You're a third wheel in the best sense of the word, because we are joined right now with our favorite defense attorney, Bob Motta, to talk about the Murdaugh filing.
Hey,
favorite defense attorney
joining us.
My
low
favorite
bar,
prosecutors in the whole world. I'm so happy to be with y'all. I'm excited. I'm blown away by this. So let's dig in.
Before Bob starts talking, I just want to say one more thing. There are just certain things I want everyone to understand. Number one, this is not some made up thing by the lawyers. No matter how much you hate them, they didn't just make this up. Number two, this is not some plan by the Murdaughs and this woman to, if he loses, be able to undermine the conviction. That's not what happened. There's no conspiracy here. This is pure selfishness if she did it. And number two, the evidentiary, we're at very early stages. These are serious allegations, but the evidentiary hearing will be huge.
Yeah, really quick, I want to debunk that because I think that's not debunk what you said, but debunk any sort of conspiracy theory that the Murdaughs had their hand in the Colleton courthouse for this specific matter. If the plan were for the Murdaughs to somehow get Rebecca Hill on board to tamper with the jury so that later on they could ask for a new trial and maybe end up in federal court, he would not have taken the stand because he said a lot of things that will make him go to federal court forever. And so if the plan was to be able to overturn a murder conviction because the evidence just looked so bad for him, then the plan would have been Alec Murdaugh does not take the stand, because when he takes the stand, he incriminates himself in so many federal crimes and other state crimes. That would be a terrible conspiracy. So I think that is very important here. I think if true, this is about one person's greed and not some massive conspiracy across South Carolina. And look how powerful the Murdaughs are. So don't fall into that trap, because I do think it's a trap. And look, we're always welcome to new information that may change our minds, but I don't think that's what's at play here.
And with that, welcome Bob Motta.
So hi guys, I'm super excited to see you guys in a couple weeks, by the way.
Oh, I can't wait. I was, this woman's ruining my steak dinner. Bob owed me a steak dinner.
I'm good on that bet, dude.
It sounds like the whole thing is flawed. I think the bet's off.
I don't know, man. Like I lost it fair and square. I mean, we could.
Did you? I don't know if you did.
I don't know. I guess I'm good for it though. You know what I mean? We're going to have the steak dinner regardless. And then if it shakes out at the end of the day after an evidentiary hearing, we'll figure it out after that. But
have you ever seen anything like this, Bob?
Man, no. Like when that thing came down, and it's like you wake up, you hear that they're having a presser. Immediately you're thinking, all right, what is it? It's going to be some BS. And then like I took a nap because I had to get up at like 5:45 to get Allison to the airport. I came back home, got the kids off to school, drove scout, so I fell asleep for like 3 hours, and there had already been a press release before the presser. So and they had released the document. So like I didn't really have a chance to dig into it, but I started to look at kind of what the basis was, man. And I was like, wow, this is legitimately, and like, it matters not which side of the aisle you're on when it comes to this. It's sacrosanct in terms of what's important to us as attorneys. I mean, the jury process cannot be attacked like that, and it's like, Brett, you guys both nailed it in terms of it's who it was is what makes it so damning. It's such a breach of her duty as an elected official, if it's true. That it sets you back, man. It like really stunned me. So then obviously I had to dig in. You're reading the affidavits. I agree with Dallas. I think they may have taken some liberties with their standards in terms of their argument, and it wasn't really well fleshed out. I think they're relying on the fact that the affidavits are pretty powerful, that they didn't really have to lean into the legal argument quite as much. But man, yeah, it was something like it's like the case that'll never die. I mean, it like, just when I thought I was out, they pulled me back in. It's like,
hey, Bob. So
yeah.
I've been wanting to ask you this all day, especially as defense attorney. And I think a lot of people will really want to know your view on this. So when you finish a huge trial like this case, most lawyers, I mean, we like fall back, and I have to like sleep for a week to sleep it off. It's exhausting.
Yes.
What happened in this case was the defense attorneys tried to talk to the jurors. They were stonewalled, but then to follow up really 6 months later and to do a lot of investigative work. I would love your thoughts on two things that I think a lot of people would love to know. Is this normal? Do defense attorneys or any attorneys kind of go, I've seen some people say, go hunt down jurors and try to get them to talk. Is there something wrong with doing that? And number two, is there anything wrong with them going to their houses and getting these affidavits? Are they allowed to get these affidavits from these people who just maybe wanted to shut their doors and, let this whole big fiasco put to bed and not be a part of it? So I'd love to hear your thoughts as a defense attorney and what you did when you had big cases.
Yeah, it's a great question. And frankly, just because of the nature of the business, we're typically on the losing side, right? I mean, like obviously, Allison and I are both pretty good attorneys. So we won our fair share of cases, but we lost our fair share as well. Some cases you just can't beat the facts, right? So in those cases, if we felt that there was a irregularity that would maybe have been going on with the jury, or that we thought that something may have happened with respect to the way the state may have handled something with respect. Like we had a case where the in-court identification, like for the witness, just for whatever reason, could not pick out the defendant from me sitting next to the defendant. So the prosecutor then came over and stood next to our table and like put his arm out and he says, okay, do you see anyone at this table? Like literally pointing at the defendant that you think would be the defendant. And then the witness is like, oh yeah, it's the guy in the green shirt. So it was like, and then there were a few other things. So and we always want to know. I mean, just from a practical standpoint, I want to know what worked for them and what didn't, what turned the case for them. Like just for my own edification, I always want to know what turned it for them, just so I can learn from it and move on, So, yeah, I mean, there's been many occasions where we've tried to track down jurors. I've run into jurors on cases at the grocery store when I'm like shopping for food. And I'm like, oh, man, like I've been dying to talk to you. Would you talk to me for a couple of seconds? And, most of the time they're typically, pretty affable and they'll talk to me and I'll be able to get some information. In a case like this, like you said, it's hard to explain to people that don't practice law and try cases just how exhausting it is mentally, because like you want to talk about real tunnel vision in terms of trying a case, you are oblivious to everything else that's going on in your life, including your family, like every other case that you have on your plate, it all falls to the wayside. You're just absolutely focused on it. And it's like a constant battle. It's like, if I'm preparing for your case in chief, And, we're not playing nice in the sense that you're saying, okay, here's our witness list. This is the order we're going to call in. And you've got, 50 to 60 witnesses and you're leaving it up in the air, which you frankly have no obligation to give us that information. It's not like a rule, at least where we practice, that says, okay, play nice, tell them who you're going to call. We want to try to move this thing along. So
we tell you the witnesses.
Yeah. So like there's this element of guessing. So like when it ends, you do want to decompress. You just want to, like, the last thing that I ever want to do is go knocking on jurors' doors. But if I feel that there might be something there that's worth looking into, but like in Illinois, we have 30 days before the court loses jurisdiction in order to get a motion for a new trial on file. So like, because when I hadn't looked up what the statute was in South Carolina, but like when Alice and I were looking at it, I'm like, wait, like, didn't they lose jurisdiction? Like, what is this? I didn't realize what the basis of the motion was. And then, of course, I looked up 29B and I'm like, oh, well, they have a year basically, as long as they show they exercise due diligence in terms of digging out the problem. And then I, of course, looked up when she published the book, because that seemed to be the impetus for them to go like say, all right, something stinks here. So, yeah, and I've knocked on jurors' doors. Some are receptive. Some are like, I've never had somebody slam the door. Like I always come in cordially. I'm not coming in aggressively. I'm like, oh, we'd love to ask you some questions if you'd be willing to talk to us. I'm like, no, thank you. Like I've moved on and I walk away, and I've had jurors that have talked to us for hours. The Garcia case, I mean, I wanted to talk to all those jurors, because I just felt like in terms of what the evidence was, that they went against the manifest weight of the evidence, that's just how I felt. And I wanted to hear for them, was it the fact that my client slept through the trial? Was that like a big issue for you? It's like a death penalty case and this guy's sleeping. Did it didn't matter what I said? So yeah, like, and in this case, it's like Newman had made a statement that, at the end, he's like, look, you don't have to talk to anybody. And I don't want anybody to approach the jurors at all. It's completely up to them if they want to come out and talk. If they want to do the talk show circuit, that's up to them. But but I don't know that applied to the attorneys. I think it's fair game, within reason. Obviously, you're not stalking people, but we can learn a lot from the jurors. And the same goes like if you guys get an adverse verdict, I'm sure you're like, man, where did we miss on this thing? Like we want to go and talk to them. But it's different. Like when you're a private, if I'm a PD, I'm not doing that. I just don't have time to do it, because as soon as I'm out of a trial, I'm probably working on the next one. Yeah. So for if you're in private practice, you have a little more leeway in terms of kind of like digging into it after the fact. But yeah, man, like this thing just blows my mind. It's crazy, and there's so much. Like Brett, you nailed it, man. There's just so many fascinating legal issues. I mean, like I want to ask you guys. Can Newman sit on the bench for this thing? No way, no. Right? I mean, not after what he said.
He's in the affidavits, so he's part
of
the
witness.
I mean, he's a witness in this. He's probably going to be called. I mean, truly, this whole thing is such a mess, because this is a small courthouse as well, right. And he's implicated in all of this, in that he will know certain things about what he told Rebecca. It's going to be very messy, and he's going to have to testify, I think.
100%.
Yeah, I mean, this is going to be such a mess. I mean, presumably he will handle this up until, he'll handle the evidentiary hearing and make the decision, unless he recuses at that point, which he could do. If it comes to a second trial,
he might have to do, because of what he said. Like his statement after sentencing, where basically he just flat out came and said, look, based on the circumstantial evidence, the direct evidence, everything you saw and you heard, you made the right choice here. You came to the right verdict. He basically took himself out of play as being unbiased, I think, in the sense that there's no way that he can take that. There's no unringing that bell. I mean, he's in agreement. So I know exactly what his position is.
I don't know that I agree with you on that.
So how do you couch that?
I thought, okay, well, there's two things. Number one, the statements I'm more concerned about are the ones in the affidavits and in the evidence, where he talks about how it's concerning to him that the clerk was talking to the jurors. Like, to me, that's more concerning, because that puts him right in the substance of this misconduct. Not that he was engaged in any, but that he becomes sort of a witness to it. I think the fact that he thinks the evidence is overwhelming that Murdaugh is guilty, I don't necessarily think that's bias. I mean, he has to make that finding anyway. at some point he's going to have to make a harmless error analysis. But that's only one part of it. The fact that the evidence is overwhelming, that's one part of it. That doesn't necessarily mean that the prosecution can overcome the presumed prejudice, the very heavy presumed prejudice in this case. So I don't know that I necessarily think that's a problem. But the other part where he's involved and he's making statements about her misconduct, that I think I kind of wonder if maybe he should recuse and have another judge come in. And honestly, it might be better, even if I don't think he has a conflict.
Yeah.
What you just said, the appearance of conflict matters too.
That's what
there may
I'm
be an
saying.
appearance
from my
there.
side of it. If I'm Poot and Jim, if he's not recusing himself, I don't even want him sitting on and hearing. I don't even want to argue the motion for leave to file it with them. You know what I'm saying? I don't want to take that chance. And I hear what you're saying, because you're right.
I think the allegations here are so serious, and it has
Yeah.
to do with the actual courthouse, that just for appearance purposes, it would probably be best for everyone involved to not have any question. I tend to side with Brett on that in terms of it, but I think he's in the midst of it. And also for the rest of the world, there are allegations, very serious allegations of a court employee here. We need to make sure that everything is kind of as clean as possible moving
100%.
forward.
And plus, I know you guys have real jobs, so you probably weren't on Twitter all day, but I was, of course, in a Twitter war, because there's the faction of people that are like, they've imputed their hatred for Murdaugh, which we all have. I mean, he's as bad as you can get in terms of human beings, but they're not mutually exclusive things in terms of, you can hate Murdaugh, but you can still realize that the Sixth Amendment of the Constitution matters, and it trumps Murdaugh and your hatred for him in terms of, did he receive a fair trial? I mean, there are two things that never have to meet. You know what I'm saying? So, in terms of him being at Moselle, and when they took the field trip, and people are saying, well, Judge Newman was there. How didn't he see Becky Hill wandering off with jurors and having these deep discussions? And it's exactly what Alice was saying. Look, you have to understand, jurors are coming into this as like unmolded pieces of clay. They're unfamiliar with the entire process. Everything is brand new. It was kind of the basis of my podcast. I realized 2 years into practice that my clients, when we'd walk up to the bench and, we'd do what we do, and then we'd walk out of the courtroom, and my client would say, I didn't understand one word of what went on in there. And then it dawned up, because at first, even as attorneys, we don't realize how little that they understand of that process, especially if it's their first time in the process. No matter whether you're a defendant, whether you're a plaintiff in a civil case, any of it, any movement into the judicial system is brand new territory. So those folks don't know, and they might not, because we know, Egg Lady, that's going to be an issue. When the judge Murdaughed her, when he excused the jury and he's directly asking her questions, did you speak to the clerk about this case? And she flat out said no. Now we've got a contradictory affidavit where she's saying yes. Yeah. So she's telling the truth at one of the times, and that's going to certainly be something the state is going to attack massively.
And if it were just her, I wouldn't be that concerned about it.
Exactly.
It's the other ones.
It's the other people. And Bob, I want to highlight what you just said, because, we've already said it, but it's really helpful when people hear from both sides of the V here. You said there's nothing wrong with Rebecca speaking to those jurors individually. Exactly. They could have been talking about the weather. So the fact that the judge saw, if he saw, we have no idea if he actually saw, but if the judge saw, or Harpootlian, or even the prosecutor saw Rebecca Hill talking to an individual juror, I would not think a single thing of it at all. And I want to note that, because I think it's easy to see such a powerful motion here and all of a sudden think the judge was in on it. Harpootlian sat on it until now. The prosecution must have seen it and they didn't do anything about it because they sided with Rebecca. I want to make sure that we kind of put those things to bed, because I have seen, the bailiff and the clerk of court talk to jurors all the, what? I'm not going to ask, the judge and the attorneys will not ask the clerk of the court what they were talking about, because we don't want to even skirt upon knowing more about the jury than we should, because that could look like misconduct on our part to
Exactly.
do any of those things. So I think what you said is so important there. And I think people need to understand that and put to bed kind of additional conspiracy theories of other bad actors. I think we are facing one really bad actor potentially
Exactly.
here.
And
Exactly.
I want to jump on this because I want you to confirm this because I want everyone to understand. The reason we are so shocked and horrified by this is so outside the norm. Like
Oh,
the fact that she would do this is such a betrayal. And there are thousands of people in thousands of courts around the country who have this job, who do it, with honor and would never do something like this. This is not sort of a systemic problem.
no.
This was her problem. If she did this, she basically sold out her position for fame and glory. She wanted to be on the Today Show. She wanted to be in documentaries. She wanted that book. It's shocking and heartbreaking and everything else.
And by the way, maybe I'm just like naive. I think she would have gotten all of those things no matter what, even if maybe it would not be as sexy if it was a mistrial or acquittal, but this case, as it was going on, we didn't know the verdict. And it was like 24-hour news about this case. I think she could have still made a lot of money, however the outcome was. And I think because the evidence seems so overwhelming, it was going to be a guilty verdict. But if it were an acquittal, I think Hollywood would have jumped all over it. She could have been there and been like, absolutely, it was overwhelming. This is a miscarriage of justice, whatever, what have you
100%.
about it. She could have made a ton of money, I think. So anyways, I say all that with,
I agree.
We'll see. We'll see, if these allegations turn out to be true, but we are so horrified because I've never seen this in my career.
Well, you nailed it. It's like, I was asking, I'm like, today in South Carolina, is it the norm for the and we're talking about the county clerk. Like here we have bailiffs. The bailiffs do the judge's bidding. They call the court to order. If there's, jury duty that's going on, they are hand holding the jury. They go down to where the jurors gather in the morning. They bring them up to the separate courtrooms. They go in, they cater them to during the day. What are the lunch orders? This is where we're, all those dynamics that go on with the jury, because we really do treat them as the special individuals they are. They're the sanctity of that room is treated as such. There's a reason that we stand every time they enter the room and every time they leave the room. That matters. It matters. It matters to the decorum of the court. If we lose that, we lose everything. So all those things, and the three of us would never in a million years. I wouldn't even I wouldn't even have sniffed it if I would have seen her talking. I wouldn't have been like, ooh, well, is she talking? I never would have thought it. It never would have entered my head at all.
Even when the judge says, I don't like the fact that she was talking to the jury, Jim's just like, yeah, that was weird. He doesn't demand a mistrial because he doesn't. He also
we would
never
allege something like this because it's such a huge allegation, right?
It doesn't happen. It does not happen. It's just that's what makes it so stunning. It does not happen, especially from somebody in that position. She's an elected official, and it's mind blowing. It's you said, Alice, getting sucked into that vortex of that case. In terms of cases, and Brett said it a long time ago, this is it's one of the best cases in forever. We've got those incredibly classic cases that we'll think about in perpetuity. And you had OJ for all the craziness that was, and you had a judge that lost control of a courtroom and the defense was running the show, and it was insane in an entirely different way. And but it's just one of those cases where the entire world was watching. And I think that she got sucked into that vortex of fame and fortune. And I'm making the appointments with the media, and I'm running the game here, and they're coming to me for the, and it's she just lost sight of it because I can't think of any other reason, because she knew better. That's the one thing. She knew better. It's her oath. It's her duty. And she broke it. And it's going to cost the taxpayers a ton of money to retry this thing. For everything that Alice was saying about, look, the defense has the playbook, so does the state. But you know what? It's not about that. State has the burden. It's a much bigger advantage for the defense. And I just got off a live with Dr. Kinsey, and he's like, I don't even know if I would do it unless Creighton sits down with me and basically, appeases me to what, because he's like, I have other clients, I have other stuff to do. I don't know if I'm willing to do it. You know what I mean? So they're not necessarily going to have all the same witnesses. It changes the dynamic. Like, plus Griffin's getting a second chance at not opening the door on the roadside shooting. You know, maybe some of the financial stuff where he'd kind of like cut it off a little bit, where Griffin made another mistake, opened the door to that, the floodgates open. Like, they're not going to make those mistakes. Like you said, if Murdaugh's an idiot, he's not testifying, but I think he's such a narcissist and such a egomaniac that he's not. His mindset's going to be, I know I could do better. I know I can convince him. That was all you just made. You know, I just got to change a couple. Like, that's his mindset. So,
but he gets a do-over too, even if he does testify.
Totally. You know,
he can learn from his mistakes.
Yeah. He's
like,
not going to walk into those same issues.
They will crowd test that crap. And I bet you people will be like, I didn't like how you called him Paw. And he'll probably change. You know what I mean? Like 100%. He can actually test all of these things and see what comes off good and what comes off bad.
He'll change his story about the badge.
Right.
You know, they slammed on the badge. He'll change his story about the first time he lied about being down there.
That's
because they slammed him on that. I mean,
you and I had that discussion months and months ago, like while the trial was going on, and we both he just took the wrong approach with that. He had to have owned it and said, look, I did lie about it, but I lied about it because I knew that you guys were looking at me as the guy. So like, I wasn't going to put myself in a position where it made me even more the guy in your eyes. And it was that simple. There was nothing nefarious about it. I just wasn't like willing to put myself in that position because I obviously didn't know that my son had taken a video that was going to blow up my entire world and create a timeline in which that, you know, like they were able to establish the time of death. You know, it's like that whole aspect of it is crazy. But man, there's just so much. Like when I see something like this, it automatically makes me think that she's done it before. Like she was so casual about it. You know, like it automatically makes me think, man, is it possible that she's done it before? Even if it's just like, I'm just casually talking about the case. It's like, I don't consider it to be material to the case. I'm not telling him which way to vote, which, you know, like, but like it's potentially going to be a nightmare scenario, because I'm telling you, if I had a client that had a trial with her as the clerk, I'm looking into it.
I'd be talking to every juror.
And Bob, that's a great point, because I think all the things that you said, that this is going to cost taxpayer dollars, it's going to, by the way, all the witnesses who have like vicarious trauma, real trauma from testifying, I think the biggest blow to all of this is on the judiciary system, right? The fact that we are all so outraged is a good thing, because I think it shows that this doesn't happen. But you betcha everyone else out there who may not be in a courtroom very often, they're going to question every conviction. They're going to basically say someone in that courtroom is trying to do something to sway the jury. And that is a huge hit on the judicial system. That's a huge hit on our justice system, because guess what? Actually, the jury system is a fantastic protection for anyone accused of a crime.
Yeah.
I mean, it is thank goodness we have the jury system, and it's not just up to one judge.
Can you imagine?
Yeah. I mean,
as flawed as it is, it's the most beautiful system on the planet. Like there's no better legal system than ours. The Constitution's my Bible, you know, I mean, it really is. It's like, it's everything to us as a society. Like, you know, so to me, you guys know how crazy I am about the Constitution, but it matters. It has weight. It's the foundation. It's the bedrock of our society. It's how we started this country. That document is beautiful, and it's breathing, and it's alive, and it's fluid, and it changes. And it's everything that we base our entire legal system on, and really our society. So it's like, we have to protect it at all costs.
And I just want to say to the people in the chat, there are affidavits from jurors who voted to convict this man saying that she did these things. Right. Maybe she didn't. That will be decided later on. There will be an evidentiary hearing. But just because we all liked Miss Becky back in the day doesn't mean that we should assume some sort of like halo over her. She wrote a book that she was writing during the trial She is now being accused of doing these things with affidavits, sworn affidavits under penalty of perjury about things she said and things she did. These are serious allegations. They need to be taken seriously. Absolutely, there needs to be a hearing about this with testimony, and we need to make sure that it actually happened. It may very well be the case that at the end of that hearing, we'll decide all of these affidavits are wrong and she didn't do this. But if you're sitting there thinking this is like, well, why should we believe this? It's just Pootie Poot and Jim. No, guys, this is really serious. It's far more serious than any motion for a new trial I have ever seen.
Me too, man. Me too.
Never seen anything like this. Never seen anything
hair
like
back,
this.
dude. I was stunned. All right, so Robert Palmer asked an awesome question that I definitely wanted to ask you guys. And what is the scenario if Becky Hill decides to take the fifth? Because I mean,
that's a great question. Because
I mean, man, it's like, think about that. Like if she decides to assert her Fifth Amendment right at that point, I mean, it's basically an admission that she's not willing to. I don't know. It's like the whole scenario is so crazy.
Well, that's actually really
case,
interesting. You can only plead the fifth if there is a possibility of criminal. Right? Am I right about has to be,
there is absolutely a possibility of criminal prosecution here.
I know that. But if this is interesting because there's potential civil charges that can be brought. So it would be interesting whether, we've seen situations where the prosecution will come out and say, like, we will not prosecute you based on this, so you can't assert the fifth. Right. I'm not sure that this is the situation in which they would do it. I only note that because it has, in a blue moon, happened before. It doesn't absolve her of everything, but she can only assert it if she could.
If I'm the prosecution, I want her to go to prison.
That's right.
So I would not be giving her
why I only note it because it is a possibility. It is a chess piece that can be played.
Oh man, it's such a crazy scenario, though. It's like, because for all intents and purposes, if she takes it, if she pleads the fifth, that she, like, you have to assume that what she said, in terms of at least what was alleged in the affidavits, was true. I mean, you can't take it any other way, right?
If the jurors get on the stand and say that she said these things and did these things, if they say that under oath, subject to cross-examination, and then she takes the fifth,
that's
absolutely.
Yes.
I think
because then you have to weigh the evidence of what you have, and we do have her words in some of the transcripts, and so we have her words in the book. That's fair game as well. So I think if those jurors are cross-examined, then this is the evidence that you have. You have to weigh the evidence before you. We say this in jury trials all the time. They can only weigh the evidence that's presented to them, and if what's presented to them is, cross-examined testimony of jurors and plead the fifth, there's the evidence.
It's a never-ending just cycle of like craziness with this case. It's like we could talk about this for 10 hours, like literally, because it's just like the whole thing is so fascinating. And now it's moved into like the horrifying territory, because it's like, I mean, if you're the state, are you weighing the concept of like, and I don't know what he's potentially looking at from the Fed side of it on the financials, but I'm assuming it's going to be a hefty amount of time considering what his age is. Theoretically, could he be doing life on that? Do you, like, if you're sitting in South Carolina and you guys are in the war room and you're like, all right, let's assume the worst here. Let's assume that he's going to be ordered to have a retrial. Is there a concept where you're saying, let's not even do it? Like the Fed, because like, I know that there's that argument out there that like, the maneuvering that's been going on is in order to get him into a federal facility. I mean, like, does anybody really care what facilities it? Like, it's moderately nicer, I guess. It's still, prison is prison to me. Like if you're in a cage, you're in a cage. I mean, look, federal joint, man.
So if he gets a new trial, then I think you're right. The federal cases will be resolved beforehand and we'll know what he's going to get.
Yeah.
And I think he will get significant time based on what his co-conspirators got. He's going to get the most.
Right.
He, like you said, given his age, that may be a life sentence. I think you got to try it again, though. I don't know that you cannot.
I think you'd have to try because, those are the financial crimes and we have victims here. I mean, not that you don't have victims with the financial crimes, but you have two people who've lost their lives here. Now, it may make a difference for him. If I were Murdaugh, I would not. I know a lot of people have said, oh, he'll just take a plea deal. If I were him, Heck no, I'm going to
No way.
trial. I have the playbook and I am going to win. Like he has a much better chance the second time around, having had a dry run. Essentially, you have all of the secrets of the prosecution. And I don't actually mean secrets. I mean their entire playbook, their exact questioning. You know this, Bob, from doing trial. You
100%.
have literal outlines that you're going to dig out again, and you're going to ask the same type of questions because you have to meet the same elements. So he literally knows what questions will be asked of all of the witnesses the second time around. No way, if I'm Murdaugh, am I going to take
the best comparison is like when you freshman year in college and you joined a fraternity or sorority and they had the cabinet that had all the tests from all the professors for all the first year and second year classes. And they had the collection and you're going in and you're able to review all that. And if you have the professors that never change, like I had a law, my outline that I got for 3 or 4 classes with the same professor in law school, the guy never changed one word, down to the jokes that he gave. The person who did the outline that gave it to me, was the exact same outline. The guy never changed one iota of his dialogue for the entire semester. So having that is such a huge advantage because you know how to prepare for it ahead of time. It's like you said, from Murdaugh's perspective, yes, 100%. There's no way he's pleading. There's no carrot. It's like the same argument, in a death penalty case, if they're going to take it off the table or if it doesn't exist, you don't have that carrot to offer. You have no reason not to go to trial. You know what I mean?
Remember, we've talked a lot about this when we were covering the trial. There is a very real difference between being someone who's been convicted of financial crimes and a murder of your own child.
Oh, no
and this matters to everybody. Absolutely.
In the joint, especially, it matters.
Sure. That's a really good point.
Yeah, your life is way worse if you're a child killer in prison than if you're a white collar guy. That, it's night and day in terms of you're under constant, you're doing this all the time if you killed a kid in prison. It's always looking over your shoulder.
So here, I have a question for you, Bob. Second trial happens. Murdaugh decides not to testify. He's now asserted his right not to testify. He's now an unavailable witness, which means that his prior testimony taken under subject to cross-examination there's a hearsay exception to that. Can you enter his prior testimony into the record in his second trial against him?
Man, I think that you can, but it's such an interesting legal argument though. It's because I was actually researching that exact issue today because I didn't flat out know the answer because I'd seen a couple people say, oh yeah, if he decides not to testify, they're going to be able to get his sworn testimony in because he's an unavailable witness. But the question is he truly unavailable? You know what I mean? It's like that. To me, that's what the balancing act is going to be if he's refusing, which is his absolute right not to testify against himself potentially. But it's such a fascinating. What do you guys think? I think that there's a good chance that they're getting it in.
It's also a prior statement of an opposing party.
Right. I don't know though, because then you have to test the bounds of how you can plead the fifth. It's not pleading the fifth if you can allow the previous testimony to come in. But if he had said someone to someone else, that's a party opponent statement that does come in, and Fifth Amendment rights aren't implicated. So I think it's an interesting question.
He doesn't even assert his fifth. He just chooses not to
testify.
You know what I'm saying? Take the fifth out of it. Just if he decides, well, I'm not going to testify because they're concerned. But there's going to be a motion to eliminate about that.
Oh,
so they're going to know going into it, and they're going to figure out whether or not that's coming in. And if it's coming in, he's definitely testifying. You know what I mean? So it's he's going to have to.
But then if he testifies, you can use his prior testimony to impeach him.
I know. It's he's going to have to. It's going
to be an interest. It's going to be wild. It's going to be crazy. It's going to be wild.
Let me ask you this too, Bob.
It's an unbelievable case. It's just so crazy.
It's possible we'll have this evidentiary hearing. These allegations will not be substantiated. Becky will be suing Harpootlian for defamation. We can watch that trial. Exactly. Yeah. But assuming that doesn't happen, assuming we have this hearing and the allegations are substantiated, do you think it's pretty much automatic we will have a new trial, or do you think there's any chance that the sort of high standard for harmless error in this case could be met by the prosecution.
I think, like, and this is what my gut is, and it's based on everything that we've been saying tonight. I just can't see a world in where these witnesses came forward, these former jurors, and are making it up. And if I'm taking it at face value and looking at, is it possible or more likely than not that he did not receive a fair trial based on what she did? Like, to err on the side of caution, he's getting a new trial. I mean, like, we can't mess with the sanctity of the system. We just can't. We can't take that risk. It's not worth it. So I think that ultimately at the end of the day, I think that it's, even if she testifies, even if she says, okay, I didn't say that stuff, they're blowing out of proportion. I don't know where they're getting it. I don't know how they're all saying the same thing. You know, when I was in the bathroom with this person, you know, we were talking about what we're going to order for lunch. It had nothing to do with the trial. And she goes on and, you know, basically comes out with what she feels are valid excuses as to every conversation. Those were offhand comments that I made. I certainly wasn't trying to guide the jury and say, look, I was just saying, you know, keep your minds open, you know, focus on the things, focus on everything. It's very important to watch every single movement that a witness makes because we're trying to judge.
Which, by the way, you still can't do.
Yeah.
Which, just by the way, anyone listening, Bob is such a good lawyer. He might be. Just know that you can't even do that.
You can't say any of it. You like it's Alice, you were talking about it. It's like that speech that they give us. Please, if you see a juror, you see one of the participants in the trial in the hallway, and they just do this when they're walking by. It's not because they don't want to be your friend or they're rude or they don't like you. They cannot speak to you under. If I see somebody in an elevator that's a juror in a case, I'm waiting for the next elevator. If I see somebody in a lunchroom, I'm leaving the lunchroom because I can't risk ever having like an ounce of impropriety in any way, shape, or form. They're even in the same room, like, oh, you know, did you slip them a note? You know, it's like you avoid it like the plague. Yeah.
Alice had a witness hug a juror once.
Oh, yeah. Oh, I couldn't control. I mean, it was an open court. Like it was. I had nothing to do with it. The judge was like, "Whoa, keep moving." But
they love that guy so much.
They really did love that guy. But Bob, let me test what you said just a little bit, because I think it's two different things, right? Like we talked about that if there is an evidentiary hearing, there's going to be first whether these affidavits hold up. Let's assume that they did. And I agree with you there that I don't think these are made up whole cloth. It might be something more innocuous like, well, I didn't hear it firsthand. I heard it from someone else. And I actually didn't hear it either. After the fact, we were talking about what we remembered and that person said they remembered. So I agree with you. I don't think it's made up whole cloth right now, but it may not stand up to cross-examination. That's not what I find interesting, because I think there's going to be a very good likelihood that with all of these similar comments from different affiants, something's going to come out. What I find more interesting, and this is going to bring in your experience from court and also from voir dire, is the jurors have to be able, the jurors who have sworn testimony here have to also say, but for what she said, I would have voted a different way. And I say this because you and I both know when there's voir dire, people say crazy things that could get them disqualified from the jury, right? They say things like, I can't believe any law enforcement officer. If they wear a badge or a uniform, I don't believe them. And then what does the judge do? The judge tries to cure it, right? They ask questions to see, well, I understand you don't like law enforcement officers. Can you put that aside for this case and listen to my instructions and give the same weight to all of the testimony you hear? And almost always people are curable because people like to be agreeable and they don't want to be that person who is like giving the wrong answer, because there's a right answer to that question, right? Exactly. And so oftentimes we are able to cure a juror before they're sat.
Much
but
to
we're
my
like,
chagrin.
whoa, I still don't want them. I want to
much
them.
To my chagrin.
Right, much to your chagrin, but that's why we get strikes, right? And that's oftentimes why the attorneys say, okay, this person's technically been cured. They said they can follow instructions, but what they told me ahead of time about all their biases, they're not going to be good for my client or for the government. So I'm going to strike them, not for cause, just because I don't want this person on my jury. There's going to be that same sort of analysis here. And knowing how we see jurors often get cured, do you think that these, particular affiants being questioned about whether they really would have changed their mind given the weight of the evidence? Because the prosecution is going to come in and say, really? You would have changed your mind even though you saw this video and you saw this and you saw this and you saw, it's going to be a lot that they're going to have to say, I would have said not guilty.
Right.
It's going to feel like a lot of questioning, and it is a pretty high bar that the prosecution has to meet here. Do you think in that instance, what's your prediction here?
I think the bar's lowered because of her office, to be honest with you. I think if it was anybody else, that what you're talking about factors in terms of the judge making a ruling on it. When you look at it, because like the way that I was trying to explain it today is like the human mind is just so fascinating. We know so little about it. 6 months post verdict, you're sitting there and you're trying to go back to sitting in that room on that day when you're deliberating and trying to figure out the impact of what she said and trying to truly understand whether or not it impacted you in a way, if you were on the fence, that it tipped you over towards guilty is so impossible to really come to that conclusion, because like our minds are just so fragile in terms of like that. Like, how do you pinpoint that? Like, how are you able to actually say, okay, I can say with great certainty, had she not said that, I would have voted not guilty. It's like because that situation didn't actually exist. Like, how can you say that unless you're in the situation with the attenuated pressure of the situation? It's like practice in games. Like, you can practice and practice and practice all you want, but there is no replicating game time experience, right? And it's like kind of the same concept in terms of a jury, and like for like that amount of pressure that they feel when they're in that room and they have the weight of the world. It's like we're always so like thankful to jurors, because that is an incredible ask from us as the attorneys in the court to say, hey, we're asking you to sit in judgment as somebody that can potentially end their life, or it can put them in prison for the rest of their life, or for any portion of their life. It's a huge thing to sit in judgment and make those judgments, knowing what the result of your decision is going to be at the end of the day with respect to that person. So it's like, I don't know, like if I'm the judge on it, I'm tortured by it. But at the end of the day, if I feel like I'm taking that concept into consideration and I'm saying, look, I'm going to err on the side of caution here, because I just don't know that without all the circumstances being put into place that the person can actually answer it like truthfully or honestly, because they just don't know the answer. Not because they're trying to be evasive, but because it's really, really hard to give an accurate answer as to what you may have done, because the other circumstance never existed for you to know. You know what I'm saying? I mean, it's such a hard thing to figure out. I don't know. Like, I don't know how, like, I think ultimately if it's a close call like that, if it comes out that the judge buys what they're selling in terms of these affidavits, I think it's, he's getting a new trial. I think that's the way it's going to go down.
Like, I don't trust Egg Lady. when you read her affidavit, like, if it's true that she told her everything Mr. Murdaugh has said has been lies and that I should forget about the guns, they'll never be seen again. I mean, and I'm with you, and I hate it because I think this guy is guilty of sin, and we did 10 really good episodes on this case, and our 10th episode was amazing.
I don't think we can redo it.
We're going to release the episodes again as if they're new.
Exactly.
You know what, Brett? We have the playbook of the prosecution.
There you go.
There you go.
I mean,
I'm with you, man.
If it is, lady, if it's proven,
and she's contradicted herself, and that's the other thing.
I don't know about Egg Lady.
Guys, look,
this doesn't rest on Egg Lady. Thank you.
It does. It's cumulative for sure. I mean, it's the totality of the circumstances and the totality of all the statements are what the issue is going to be. How are they going to address? Because people are going to be looking at the jurors as well. Because Newman asked, like all judges do, every day as soon as they walked into court.
Has anybody
talked to anybody about the case?
Yep.
Like, anybody talk to you about the case? No. And for the entirety of the trial, every single one of them said no. And like the only answer could be, again, they didn't know that it was necessarily her doing something wrong.
That's
They
the
just
thing.
thought-
It goes back to who it was.
Right.
That's why it's so pernicious.
She has authority. She is the court. They didn't talk to anyone because they're currently talking to the judge, and they don't really know the difference between the different court members.
Exactly.
They are all cloaked with the authority of the court.
That's what makes it so infuriating because of her.
So
position.
infuriating.
Man, it's the worst.
It's
It is the
just-
absolute worst.
Bob,
Drives
I've
me
missed
crazy.
you. It's really good to have you back.
Yeah.
You know
Yeah,
what?
I
The
miss
only
you guys
good thing
too.
if we have to cover a new trial is we'll get to talk to you a lot more
Look,
because we had a
if
lot
we
of fun.
do, here's the thing. If there's a new trial, every night we're just going to get on and talk about the trial.
Oh, totally. And I finally
We'll just do it every night.
Patreon. I'm a patron of the.
Oh, wow.
Oh.
Okay.
officially. So yeah, well, I was dying to hear 13 and 14. I'm like, I can't wait. I'm not.
Oh, you're the
So I
best,
paused,
Bob.
like, plus I love y'all, so and I always want
You're
to
the
support
best.
the
We love
show.
you too.
So yeah, and I thought you guys did an amazing job on that, and I was out there fists up.
You were,
on-
as I said, you were like a hate sponge. You were taking all the hate for us.
You
It
know,
was great.
Hate sponge is true, man. Thanks.
Oh
for that.
man, it's like I just thought you guys did a wonderful job with it. I thought it was what you guys do, what we do. There's no one in the game that does it better than us in terms of giving all the facts, giving a completely objective. Yeah, I mean, I just like it. No matter which way, I never felt that you guys came in with a preconceived notion. Because like when you do come in, like, yeah, you might be feeling, yeah, I think he's kind of guilty. Like it's always kind of run through my, but when you go through the process of going through everything that you guys did in that way, you can't help but reanalyze it, and that's what people don't understand. And I understand it because it's what we do for a living. That is what we do for a living. Like you guys tried the damn case, and I thought it was beautiful. And like, I applaud you guys. It was great. We're doing the same thing. And Brett, like the Avery's coming out, and it's going to be pretty intense. So
I'm looking
y'all,
forward to it.
I want you guys to like, and I'd love to talk about that because it's like, to me, they're hand in hand. They're vastly different, but like originally, I just wanted to kind of go through and do, I wanted to handle Zellner's PCRA stuff. Like I'm like, all right, I want to see if these things have legs. So, but of course, as soon as I start digging into the evidence, I realize immediately there's no way. Like I've got to dig into the case.
Gotta go all the way.
And I'm like, this went from 6 to probably 20 episodes.
Awesome.
So much. There's just so much there. And I'm coming in completely objective because it's like I said, I can't, as much as I love you guys, as much as I love anybody. And like, I trust, aside from myself, I trust no one more in terms of like coverage of case than you two. Like, that's it. Like it's me. But like for me, much like you guys, like I need to look at the evidence and evaluate it on my own. I just have to. It's the only way that I can come to my own conclusion. So I just realized that, man, I got to look at it all. I got to do it all. So we're going to do all the police reports. We're going to do like, and there's no agenda. Like I'm not coming in. Like I think I've misnamed the series. It's like making the case for Avery's innocence, but I
assumed you were going to say he was innocent.
That's what I
based on
thought.
the name
so
of the
I
series.
explained in the third episode. I'm like I want to be clear. I'm entirely on the fence on this. I am not. Like I can see a world absolutely where he's guilty, and I can see a world where absolutely where he's innocent. At this point, I don't know because I've never dug into the evidence, and there's no way in the world I would ever go by what Making a Murderer put out there because it was cherry picked and they had an agenda. Like that. For as much as I loved it at first blush, as soon as it was over, I'm like Googling, okay, well, there had to be more because there's no way they got a guilty verdict on that. What did they leave out intentionally to make it, frame him as an innocent guy? So then, of course, I see that there was substantial evidence that they kept out of that documentary. So to me, that put it as, fodder. You know what I mean?
Bob, last night, we talked to the guy who did the Convicting a Murderer documentary that's coming out this Friday.
Tomorrow, right? I think
Tomorrow, that's right. Or third
So-
Friday the 8th.
Friday. And he was making a lot of the same points about how that, that documentary was so well done and
Right.
was so convincing. I watched it, I was into it. I
Everyone
watched
did.
every single episode.
I
Everybody was
binged
into
it in
it.
one day.
Yeah.
But there was a lot
real.
missing out. So
Huge.
I guess watch that documentary if you're listening.
Yeah.
You'll get a preview of what Bob Motta is going to do in his 20-part series on Stephen Avery. So you guys need to check that out.
it's going to be every ounce of evidence that existed. We're going to cover the pretrial motions. We're going to see what was left out. And I'm going to account for it. I'm going to say, look, it wasn't allowed at trial, but it existed in the world. I mean, the fact that they had that Denny hearing and they denied the defense the ability to be able to, bring in a potential alternate suspect was huge, because it pushed the defense into the position of saying the cops did it all, which is never
Absurd.
a defense that I want to go at. I mean, it's like the
Right.
worst defense, because you're getting the judge to say, well, you better tread carefully if you're going to sit here. It's like there's a pat response that both the prosecution and the state are going to say, like, if you're going to challenge the integrity of law enforcement, you better have something of substance, because you can't come with some heavy duty junk. Because I mean, we've had it happen to us where we've challenged law enforcement saying, I don't know if it's a mistake or I don't know if it's intentional, but I can tell you they got it wrong. And like the judge will ream us a new one. And we're at the end of the day, he's like, when we prove it up, he's like, all right, well, you're a credit to the profession. But we're taking the beating initially. And because you're like, we're going to report you to the ARDC if you're coming with a bunch of crap. And, we're like, all right, man, we think we've got it. Like, you're scaring us, but we've got to try the case. So, yeah, it's one of those things where we're going to lay it out there, man. It'll probably, knowing me, because I'm not good at editing, it's probably going to be
Now, Bob.
howdy.
Well, thank you guys for joining us for another wonderful discussion. We always love it when Bob comes on our show. We love having debates with you. And in this case, just hearing your perspective, Bob. But until next time, I'm Alice.
And I'm Brett.
And I'm Bob. Love you guys.
And this is the Prosecutor's Legal Briefs. Oh, I love it. I love it.
All right,
Bob,
well,
this has
thanks
been
for-
awesome, everybody.
Thanks for coming on.
My
Yeah,
pleasure.
thanks,
Thanks for
Bob.
having me.
Thanks to everybody in the chat. I hope you
everybody.
guys enjoyed this. I hope it at least gave you a little bit of understanding what's going on. It's wild. It's totally
crazy.
wild.
It's crazy. And we love
This
you
case,
guys
man.
so much.
This case.
All of you guys are amazing. We love you guys so much, because I think we can agree we got the best fans in the world, no doubt.
Absolutely.
Totally.
100%.
None, bar none. All right, y'all. Sweet dreams.
All right. See you
Bye,
later.
guys.
Bye.
Bye.